It's Lil Pac, baby, in the building.
The truth teller in the building.
The pressure bringer in the building.
If you rockin' with Pac,
Make some noise. Yeah, if you got them receipts,
put it on the floor.
if you got that truth,
Put it on the floor.
if you rockin' with Lil Pac,
Put it on the floor.
hey, 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 hey. One time for the realest, bitch. Two times for the coldest, bitch. Three times for the bossed up, bitch.
Fuck it up, fuck it up.
Yeah, that's Lil Pac, bitch.
One time for Lil Pac, baby.
Let's go.
Two times for Lil Pac, baby.
That's right.
Three times for Lil Pac, baby.
Fire up.
Fuck it up, fuck it up.
It's Lil Pac,
Baby.
walk in, whole room in a G-shiv. Truth talk heavy, she don't ever miss. Stand on facts, yeah, she stand on 10. When Pac touch down, pressure step in. Spotlight glow when she hit that live. Whole chat lit when she drop that vibe. No fake love, only real ones roll. Lil Pac run the scene, that's how it goes. Clock that T receipts on sight. Drop one post on that ignite. Talk that truth, she don't play nice. Put it on the floor, expose that light. Go Lil Pac,
Go, go, Lil Pac, go, go.
go Lil Pac, go. Put it on the floor, Pac, put it on the floor. Time for the realest,
Bitch,
two times for the coldest,
bitch,
three times for the bossed up,
bitch. Fuck it up, fuck it up.
yeah, that's Lil Pac,
One time for Lil Pac, baby.
Hey, oh,
Two times for Lil Pac, baby.
that's right, oh,
Three times for Lil Pac, baby.
turn up,
Fuck it up, fuck it up.
it's Lil Pac, baby. Truth in her voice, yeah, the crowd gon' lean. When she clock them receipts, know she mean what she mean. No cap stories, she dismantle the fake. Every live she hit, make the whole chat shake. From the boot energy to worldwide view. Lil Pac, baby, got nothing to prove. Stand tall, crown never tilt. Pressure too heavy, whole lane get built. Put it on the floor, 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 put it on the floor.
Go Lil Pac, go, go Lil Pac, go. Receipts on the floor, let's go. One time for Lil Pac, baby. Two times for Lil Pac, baby.
That's right, go.
Three times for Lil Pac, baby.
Turn up.
Fuck it up, fuck it up. It's Lil Pac, baby.
If you want some weird shit, stay away. Stay away from me. Period.
No weapon should profit.
No weapon form is going to prosper.
No weapon form is gonna profit.
Yeah. What she bring?
Fact, fact.
What she talk?
True, true.
Who they hear?
Hooper, hooper.
Who they want?
Hooper, hooper.
Say it loud.
Yeah.
She don't mum, stepping in, home run, no lie, She dismantle, every word, hard handle, receipts up, no stall, name ring, head turn, she say it, that's law, truth hit, lesson learned, what she do,
Break it down.
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 then what she do, break it down, break it down. No spin talk, no fake sound. She don't whisper, she lay it down. Every claim, she press check. Every lie, she correct. Boot state, backbone strong. Stand firm, 10 toes on. She talk one, that's final. Lil Pac voice, undeniable.
Yeah. Break it down.
That's Lil Pac.
Break it down.
Facts only.
Break it down. Break it down.
Hey, Pac Squad, what's up, y'all? Happy Saturday, baby. Oh, listen, y'all. I had a night last night. I had some fun. We had a little family thing, child. But I'm going again tonight because it's a 3-day weekend type of thing. So yeah, I said let me get my live out the way because I wanted to do this live yesterday, but it was too many people live, so I didn't get to do this. Well, I think I did not. I did go live yesterday. Did I? Was it early? I can't remember, child. But yeah, I said let me hurry up and do this one and get it out the way, y'all. When I tell y'all the research that I've been doing and just watching other content and looking up things, It's a lot of attorneys that's low key doubting the appellate team with the structural, them pointing out the structural errors with Carmelo's trial. And when I tell y'all that is a firecracker, that Russell know what he doing. Okay? Russell know what he doing. Three cases three of the cases that they cited in the paperwork was Strickler versus State, Hernandez versus State, and Stedman versus State. And when I tell y'all, two of those were overturned convictions, had nothing to do with the crime, just structural errors, y'all. We finna get into it. We finna get into it, child. Listen, let me go up. Let me go up. That's why my caption is what it is, because Carmelo's case can literally be overturned and it has nothing to do with self-defense. Like Nathaniel. I'm gonna tell y'all why in just a second. Hey, Michelle Bell, shout out to you. Shout out to you and all my other beautiful minds that's in the building. I see y'all discussion board. Thank y'all for holding it down. We got Shaquintley. We got beautifully designed. We got Mr. Tree Scorpio. We got Queen Love Mail. We got Miss Yolanda. We got Toya Lee. We got Miss Geraldine. Eric in the building. We got Miss Carletta. Michaela. Tawanda. Thank you, Miss Carletta, for my first firework. Thank you, my love. Hey, Christy. Hey, Terry, bro. Thank you for that copyright and fair use. We got Miss E. We got my bro Terry coming through with 1, 2, it is 3, 4, 5 fireworks. I appreciate you and the love. Miss Michelle coming through with the firework. RG and Jerry, shout out to you. We got Miss Joyce. We got Loving My Curves. Loving My Curves coming through with the firework. Y'all's cutting up. Thank y'all. Appreciate y'all. Hey, Miss Annette. Hey, Miss Stephanie. Miss Witty. Love Me For Real. T. Stanley in the building. We got Miss Pinky, Miss Tina, Miss Hill. We got Frey in this thing. I know Frey finna enjoy this one for sure, for sure. Hey, Miss Renee. Hey, Miss Tracy. Let me see. Who did I miss? Wow L23. You say nice Louisiana accent, gumbo and chill. Listen, if I wouldn't be going to this event, I would be cooking some gumbo today because it's the perfect. Y'all, this is why I was late. I got soaking wet. I got in my driveway and I was just sitting in my car, looking at some research on my phone. Child, it just started pouring down raining. And then, I'm like, well, I'm gonna wait till the rain stop to go in the house. I needed to pee. I had to pee so bad. I said, Lord, I'm about to get soaking wet. And I got soaking wet. Ham was laughing at me, child. I'm like, Mama, you soaking wet. I couldn't help it. I needed to pee. I had to catch that rain. It's all good in the hood, though. Hey, Miss Yolanda. Thank you, Miss Hill, for that other firework, my love. Yes, free Karmelo, baby. I think he coming home, y'all. With this right here, he got a big chance. I would give it at least a 95% chance. They say the appeals is hard to get overturned, especially in Texas, but this has nothing to do with the appeal. This is just on structural error. That's how cold Russell them is. And they did all of this without the transcript. Baby. Yeah, they did a big one. Hey, Miss Cynthia. Hey, Vonda. Who else in here? Let me see. I know Scorpio. Yes, y'all definitely say a prayer for Dawn. I don't want to speak too much on the situation. I'm gonna let her do her own big one too, but definitely pray for Dawn. It's so unfortunate. I wish, people would just leave it at the internet, but unfortunately they can't. Okay. So, it is what it is, but I'm definitely praying for her and her peace while she's dealing with that situation. Let me go down. Hey, Miracle Child. Hey, K Monet. Hey, Miss Blaze. Who else in here? Melody, grown folk and stuff. Okay. Shout out to everybody that's in the building. We're going to do a collective hey for anybody else that comes through as we progress in the dialogue. If you would like to donate to your girl monetarily, you can cash out me at $Lupac2. You can also buy me a coffee. Shout out to my coffee people. You can also support the platform by getting a super chat or a super sticker, aka a firework. Y'all know the vibes, child. You can also support me by getting a membership. Shout out to the green team, the OGs, the newbies, and the in-betweens. Y'all know who y'all are. Shout out to the POC squad. Y'all make it look like money in the chat, babe, because y'all always VIP. They can't touch us over here. Period. If nobody else show up, the green team gonna hold it down. That's one thing I gotta give y'all. I love that fuzz. Make sure y'all watching them ads. Please hit the like button at the end of this live. Hype your girl up. Y'all know the vibes, y'all. Y'all know the vibes. Y'all. So, like I said, I've been doing my little one too, and shout out to Legal Doc over there. She's a paralegal. She don't have like a big channel, but she's powerful. I'm gonna just say that. So make sure y'all go check her out. Legal Doc. Hey, Miss Dorothy. Hey, Miss Bonnie. So, oh, Dawn is that's in the Latroot sector. Who asked that? Wild L23. That's in the Latroot. Y'all, a lot of the people that's in here, they not from the Latroot sector. So y'all might have to, put up prayers when we do a saga live. I might, oh, child, maybe I might be able to do a little quick one too on the saga. It just depends because I gotta bake some cookies real quick to bring to that event. So I'ma see if I have time. I'll do a little quick one because I do want to explain something legally over there within the saga, but it just depends on my timing. Okay. All right. So let's get into it, y'all, because time be going by fast, y'all, and I want to get all this information out. Hold on. I wonder if I could pull up my chat GPT. Let me see. Hold on, y'all. Let me see if I could pull up my chat GPT on here so y'all can see what I'm finna read to y'all. Because I took some notes too, but I want to be able to put it on the screen. Let's see. Hold on 1 second. Come on, mouse. Let me see if I can log in. I need to keep it logged in on my computer anyways. Yes, log in right there. Let's see. Did it log me in? Damn, I gotta get my age. Hold up, y'all. I'm coming. Come on, baby. Come on. And hopefully the rain don't mess up our power because the rain is crazy right now. Search chats. No, I need to go to ones I already had. Projects created by you. Hold on, y'all. Shared with you. Where's the stuff I already? New chat. Hold on. I don't know why it's not showing the stuff I already searched. Waller Test, Texas. Hold on, let me see. Oh. Come on. Close sidebar. Files, images, projects. Waller. Let's see what happens. Damn, it's not opening up. You would think it would have my files already. View files in chat. In chat. Archive. Okay. I don't know why it's not pulling up the stuff I read. Lupa, can they tamper with the transcripts? Listen, I don't put nothing past them people. I ain't gonna throw no speculation out there. I'm gonna just say I don't put nothing past them because one thing that I did read in the motion is that an attorney was trying to get access to the transcript and the judge was trying to basically silence the attorney, that they could see the transcript but only in his chambers and they couldn't speak on what was in it. So at this point, I don't put nothing past none of those people, okay? Because they doing some grimy shit. Y'all see what we dealing with. So yeah, I ain't gonna say that they tampering with them, but I'm gonna just say I don't put nothing past them because why aren't they transcribed already? Why haven't they been released to the public? Why are they sitting in the judge's chambers under lock and key? That's the number one question at this point. So, I'm pretty sure Russell them, they know they know how to work the system and get it to where it can be released. I did hear Thelma say that they gonna get their hands on it. It's just a matter of when because they on a timeline. And I'm pretty sure even with the timeline, if somebody is willfully withholding court documents, then it got to be some type of wiggle room around it. Like, they couldn't even base their motion off of the transcript because they're withholding it willfully. So it's not the appellate lawyer's fault. Some chastising needs to happen just off of that alone. Child, listen. Okay, so let me see, y'all. I was trying to pull up my chat GPT chat, but it's not letting me, it's not showing my history. So what I'm gonna do is I'm gonna put this on the screen just to have something on the screen, and I'm gonna read to y'all what I got. Because I don't want y'all to be waiting while I try to figure it out. Because it's too much. Okay. I don't want y'all to because some people be impatient too. So we're gonna just put this on the screen. This is a reference point. And I'm going to start reading to y'all what I got. Okay. So let me see. Do I want to go to my notes first or let's see. Hold up, y'all. I did take a good bit of notes. All right. And then popped up. Let me pull it up real quick because I want y'all to see this. Another thing that was noted in the motion is that I don't know if y'all knew this, but because I didn't even go through the whole motion, but did y'all know that Karmelo's grandfather and some of his aunts was not allowed to get into the courtroom? That's major. And I'm gonna tell y'all why when I read one of these case laws. That is major, y'all. Family was not, it's supposed to be, a certain amount of seats for family, but if y'all notice, one thing that I paid attention to was boots on the ground, people that was actually in court, like Meek and Queen Sheba and Mel, and just different people and the things that they were stating as far as prejudicial treatment while they were in the courtroom. The Metcalf family was able to get more seats than the Anthony family. They was literally strong arming people, and bailiffs and judge not ju- bailiffs and security was allowing things to happen that was supposed to be against the rules that Judge Roach put out. But different skin folk get different treatment. So that's the crazy part. Hey Luna. Hey my love. Hey to everybody that's coming in. I see y'all. You say we staying in a hotel in Biloxi. Ooh, prayers to y'all. I don't know if it's raining out there, but it's storming here. But hey to everybody that's coming in, y'all. Please hit the like button. We got 173 in here so far. And also, if you want to support me even further, you can support my little gold child. All right, so let's get into it, y'all. Let me pull this up. Now, this was in the motion as an exhibit, right? This is an exhibit. Let me put this down so I can put this on the other screen. Is it big? Yeah, but I want to make it bigger. Hold on. Okay. All right. So this was in the motion as an actual exhibit, y'all. And it was basically to showcase everything that was restricted as far as the courtroom was concerned for Karmelo's trial. Y'all see everything that's in red? Yeah. That's everything that was restricted. Now, I do have to show y'all this. This is the main thing. Before we get into those three case laws, let me read this to y'all. Because remember, I was supposed to read this to y'all when it first came out, but we hadn't talked about so much other stuff, child. So I'm gonna take this down for a brief second. Let's see. And I'm gonna pull up. Y'all remember, okay, y'all know about the interview that Judge Roach did. Y'all know about that. He did an interview. Was it with Fox or WF? One of those. And he also put out a written statement. No, he also gave an interview, like a written interview type statement to another news place. And he also put out a gratitude letter. Let me show y'all this. Shout out to him for doing this because he don't realize how he effed up by putting this out. And I don't think a lot of other people realize that either. This was major. So this was the letter that Judge Roach put out as, like a thank you to everyone who assisted with the Karmelo trial, right? It also shows that he's acknowledging that Karmelo's trial was quote unquote special, right? It's like he going against the grain. Like, did you thank everybody when you did other cases, other trials, or is it just this one? Because we can see, as far as it's a lot of things that are questionable surrounding this trial. So let me read this to y'all, and then we're gonna get into where he effed up. June 16th, 2026 is when he put this out. To the members of the Collin County family, as the presiding judge of the 296th District Court during the recent trial of State of Texas versus Karmelo Anthony, I want to express my sincere gratitude to the countless individuals and agencies whose professionalism, dedication, and cooperation made it possible for the court to fulfill its most fundamental responsibility, ensuring the fair, orderly, and secure administration of justice. Right? Note how he emphasized on, well, he put fair first, even though we know ain't nothing about that trial was fair in the lens of justice. Okay, period, point blank. Nothing about it was fair. This was definitely like a little 1-2 cover up. Let me cover my tracks even further by putting this out to the public, just to put a little extra stank on it, right? Let me put a little extra stank on it to, make it try to manipulate the people. That's what I took from it. So let's keep going. He then says, trials that attract significant public attention require extraordinary preparation behind the scenes. Notice how he's emphasizing on the preparation, right? Even though we know, based on boots on the ground, people that were there, it was a hot ass mess because they was fighting for spots, fighting for parking. They was like restricting people so bad, certain people, let's say that, certain people of color so bad to where I remember Neek saying that she had to drive around multiple times to not be in the parking lot because they would kick them out if they was in the parking lot before a certain time. That is crazy. Let's keep going. And then, not just that, she also said, and then after she did that, once she finally parked, they had like 20 something people in line. So clearly, certain restrictions were for certain people, and others, they got a little one too. So let's keep going. He then says, while much of the public focus is naturally directed towards what occurs inside the courtroom, the truth is that the work of administering justice depends upon the collective efforts of many people, most of whom serve quietly and without recognition. I extend my deepest appreciation to the Collin County Commissioner's Court for its unwavering support and commitment to ensuring that the resources necessary to conduct this proceeding were available. I am equally grateful to our budget department, information technology department, human resources department, auditor's office, CSCD, public works, and facilities department, each of which responded to challenges with professionalism, flexibility, and a willingness to do whatever was necessary to meet the moment. Let's keep going. Okay. I offer special thanks. Here's where it gets interesting. No, this is not the part yet. I offer special thanks to the district clerk's office and jury services staff that for their timeless efforts in managing the enormous logistical demands associated with jury selection and trial administration. Their work, y'all, notice how he's also emphasizing jury selection when 3 black jurors were struck for damn near no reason at all besides being black. For the reasons of them being educators. And they still had a white educator on the jury. Oh yeah, Russell them got a lot to work with when it comes to errors and violation of rights. Okay, they got a lot to work with: constitutional rights, the Sixth Amendment, structural error. It's a lot to work with. Besides, that ain't even counting ineffective assistance of counsel. Baby, they got a lot to work with. Like, they really did they big one on Karmelo's trial. And people wondering why we still talking and still fighting and advocating. Are y'all okay? Like, some of these people are weird. Let's keep going. So, where did I stop? Hold on, y'all. Let me see. Okay, their work ensured that citizens called to serve were treated with dignity and respect throughout the process. I guess that don't count the ones that were struck. I also wish to recognize the extraordinary efforts of the Collin County Sheriff's Office, whose deputies and leadership devoted countless hours to maintaining the safety and security of all participants while preserving the integrity and decorum of the judicial process. How, when you had Nika Knight crying on camera because the Proud Boys were able to surround her and intimidate her with masks on their face and pum-pums. What the hell? Who the hell was the deputies securing? Because the Black Panthers had to go out there just to give her a little ease of mind. Like, make it make sense. How is it that certain people were able to be intimidated and confronted? I guess as long as nobody touching you, it's okay if you are a certain color of skin. Like, we got to make it make sense, baby. Them cops ain't did shit. So let's keep going. Let's keep going. My gratitude, and this is why he did this, y'all. This is a form of manipulation, in my opinion, just to put a little extra stank on it to make it seem like he did exactly what he was supposed to do as far as securing the place and being fair with the all of the stuff, child. But we know what really happened. So my gratitude extends to the Texas Department of Public Safety and to our law enforcement partners from the McKinney, Allen, Frisco, and Plano police departments. Y'all, they had all of those different counties out there assisting them. For them to still have all these issues, that alone shows that only a certain color of skin was assisted, basically, because how do y'all have all these complaints about this trial if y'all did y'all job correctly? Make it make sense. So let's keep going. Their collaboration, planning, and visible presence provided reassurance and protection to all who entered the courthouse. No, it didn't. I likewise thank the Collin County and McKinney fire marshals. They had the fire marshals too, y'all. The fire marshals too. Offices for their expertise in assisting and ensuring that appropriate safety protocols and emergency preparations were in place. This is my thing, right? What the hell was the purpose of them hiring all this extra security when they didn't let nobody in the damn courthouse? Like, what was the purpose, y'all? What was the purpose of them hiring fire marshals, McKinney Police Department, Allen Police Department, Frisco Police Department, Plano Police Department? What was the purpose of them having all of that extra security when nobody damn near was allowed in the courtroom or the overflow room, for that matter? Oh yeah, baby. He trying to do his big one with this cover up. Let's keep going. All right, let me get the other page, y'all. Let's take this one down. This is important, and I'm gonna tell y'all why in a little bit. Okay, this is very important. This statement he put out. So let's go. Oh, why did this pop up, child? Hold on. I don't know if y'all can hear that, but stuff popped up. Okay. Can I make it a little bigger? Let's see. Oh shoot. Wait. It might not go no bigger. Damn, I'm gonna have to leave it like this, y'all. Okay, that's good. Long as y'all can see it a little bit, I can see it to read it. So all right, let's keep going. So he also said, this is page 2, y'all. We got 223 in the building. Make sure y'all hitting that like button for your girl and sharing this live stream out. He also said, I would also be remiss if I did not recognize, this is it right here. This is a key part that everybody needs to put in the back of their head for once I start reading this other stuff to y'all. Remember this part right here. I would also be remiss if I did not recognize my fellow judges of Collin County. Throughout these proceedings, they modified already demanding schedules, adjusted their own dockets, and accommodated the unique needs of this case without hesitation. Let's stop right there. So, what that means is the judges, y'all know, if y'all familiar with court proceedings in a courthouse, there are multiple rooms, right? You might have Judge John's room. We're gonna just throw out some names. Judge John's room, then you'll have Judge Thomas's room, then you'll have Judge Waller's room. So it'll be like a couple different courtrooms in a courthouse, or might have the first floor or the second floor, in different rooms. You got the clerk of court, you got all these different little offices, and then the judges' rooms in the courthouse. So what he's saying is, and mind y'all, they had court on a Saturday also, which is very, 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 very rare. I don't even want to use rare because I've never seen it happen. I've never seen court happen on a Saturday. Like government officials and buildings and stuff, they don't even be open for holidays. Courthouse, like government jobs are closed every holiday. How the hell y'all have court on a Saturday? That is weird to me. But it just shows that like what the whole process was rushed. Basically, somebody pulled a whole lot of strings for this situation. Even as far as getting Karmelo transferred the same damn day, somebody pulled some strings, baby. Oh yeah, they had a plan in motion for that baby. They had a plan in motion, but God intercepted. God did his big one and still doing and still will do it. Okay. So he basically saying that all of these other judges that had courts and dockets of their own around the same time as Karmelo's trial, they move all their court shifts around to accommodate this trial, which means they had more than enough space to house or to assist the public. They could have put monitors or screens in other courtrooms, even outside of the overflow room, so that the public could be accommodated. What was the purpose of the other judges moving their dockets around and they're already demanding schedules, like he said, if they wasn't going to utilize the extra space? That is very, very important, y'all, because remember, Russell them cited that Karmelo's grandfather and his aunts were not allowed to be in the courtroom. Okay? And that is close family. That is immediate family. They were not allowed. When you had Austin had the distant cousins, I'm exaggerating, but they had about 20 something family members of Austin in the courtroom. And Karmelo's grandfather and aunts, I think two of his aunts couldn't even get in. Let's make it make sense, right? It was a case that was literally overturned just off of that alone, off of a one support person not being accommodated. Conviction overturned. I'm gonna show y'all in just a second. Okay, listen, we cooking, we cooking that gumbo. We ain't cooking it literally, but yeah, y'all know what time it is. Hey to everybody that's coming in. Yes, please hit the like button, y'all. We got 260 in the building. Please run up the likes for me and support my little goal if you can. Also, any color firework, y'all know I'm not a greedy child. Okay, I'm very appreciative. All right, so that's important, y'all. That is very, very important to this situation because it shows that he didn't explain why he needed. Let me not jump ahead. I don't want to get a tea too soon, but it's important. It's important because none of that was listed. None of that was listed in his motion because he had to file a trial order motion explaining on the record why he did what he did with this trial, y'all. And it can't be general. It can't be general reasons. Like it has to be very, very specific. Very specific, and you have to give alternatives. Even if you have to give alternative reasons for alternatives also. He didn't do none of that. His ass is to the fire, baby. He didn't do none of that. Okay? He gave very specific reasoning as far as it being controversial. We're gonna get to it though. I need to get that paper also. I gotta try to get that trial order, that amended trial. If anybody can get me that amended trial order paper from Judge Roach that he he filed, please get it to me ASAP. Send it to my email. It is the amended trial order motion filed by Judge Roach. I need that ASAP. ASAP no Rocky. All right, so let's keep going. We got a little bit left with this, and then we're gonna get to the good stuff. So y'all notice he said that, keep that in the back of y'all mind. So he then said, what did I stop? Hold on. They understood that ensuring the orderly administration of justice in one courtroom often requires sacrifice and flexibility throughout the entire courthouse. Why? Because you didn't utilize none of their courtrooms. So why was their flexibility needed when you didn't utilize it? He only allowed 9 media persons per day. 9 media persons. They were very strict with who they allowed in that courtroom to have eyes on that proceeding. Okay? We're going to just throw that out there. They was very specific, baby. Certain people had privilege and certain people didn't. Okay? Keep that in mind. So even to the point where they was telling some media people they couldn't even have a pen and a paper to take notes. Shout out to Neek for submitting those emails to the Dream Team, and they was able to use that as exhibits. Imagine, you are literally, they are workers of the public, y'all. Literally, we pay our taxes for these people to have salaries. So to have this much exclusion, yeah, something got to be done. Let's keep going. Their willingness to loan members of their staffs, including their individual bailiffs, provided critical support and exemplified the collegiality. Hold on. Slow down, Pop. Collegiality. I'm adding words to it. I can barely see it. That's why it's so okay. Exemplified the collegiality, professionalism, and spirit of service that define our judiciary. I am deeply grateful for their friendship, cooperation, and steadfast commitment to our shared mission of corruption. You should have added that. Most personally, I want to recognize the remarkable staff of the 296th District Court. Their long hours, attention to detail, patience under pressure, and steadfast commitment to public service were indispensable. They represented this court and this county with excellence. Ooh, he doing his big one, baby. Put that stank on it. Finally, to everyone else who played a role, whether through planning meetings, operational support, communication, security preparations, technical assistance, administrative coordination, or simply a willingness to answer the call when needed, please know that your contributions matter. The public often sees only the final product. I had the privilege of witnessing the countless acts of professionalism and teamwork that made the final product possible. Oh, baby, he putting the stank on it. The administration of justice is one of our community's most solemn responsibilities. This trial demonstrated what can be accomplished when dedicated public servants from different offices and agencies work together toward a common purpose. Regardless of title or assignment, each of you contributed to ensuring that the process was conducted fairly, safely, and with the dignity our citizens deserve. It has been one of the great honors of my judicial career to serve alongside individuals of such character and professionalism. On behalf of the 296th District Court, thank you for your service, your sacrifice, and your unwavering commitment to the people of Collin County. Child, bye. Child, bye. Y'all, you know what I want to know? He had such a great experience with Karmelo's trial, right? According to him, according to this gratitude letter, why was the first judge appointed to Karmelo's case treated so badly? Let's see who can figure that out. Black lady, black judge. She literally lowered Karmelo's bond from 1 million to 250K because she was doing her job. She had no reason to keep his bond at 1 million for one. She was doing her job. And if she wasn't doing her job, she would have gotten in trouble. She would have gotten sanctioned. She was doing her job. Just because the public doesn't like something does not mean it goes against the law. Okay? So why was her experience so horrible and dangerous to the point that she had to recuse herself because of doxing, harassment, threats? But his experience was top notch, baby. Top notch. He said it was an honor of his judicial career. Why was that lady, that judge, that black judge, his experience so horrible just in the bond process? They hadn't even made it to, that's how you know she was fair. And that's how you know our judicial system is flawed. It's flawed because had Judge Roach been appointed early on, he would have never gave Karmelo. That's my opinion. He wouldn't have. The way he ran this trial and the way they holding on to the transcript, the autopsy. Oh yeah, all of that. I personally believe he probably wouldn't have never gave Karmelo a reduced bond, which is crazy. So let's keep going. But that lady, that black lady judge, the first judge, and I believe if she would have still been appointed to this case, it would have been completely different. It wouldn't have been no off the record deals, no gentlemen off the record deals, no secret meetings in the judge's chambers. It wouldn't have been none of that. Because I guarantee you that lady run her chat by the book. No bribery, no none of that. No railroading, whether it's black or white. It's going to be fair. It's going to be fair. Period. Karmelo probably wouldn't even be in jail right now had that lady still been appointed because she would have done things by the book. She was ran off from the case for being fair. That's how you know our judicial system is flawed as okay? Very much flawed. So, Andrea says, Hold on, let me see. This letter shows guilt and that Judge Roach fully well knows what he did and the entire trial was not fair and wrong. Listen, I agree. I agree. And y'all finna see even more so. Hey to everybody coming in. Watch this. All right. So I might as well leave this up. Or should I put back up? Let's put the map back up while I read the other stuff to y'all. Hold on. Let's see. I should still have it. Let me see, y'all. Hold on 1 second. Here we go. All right. All right. Okay, so remember, this is the map, y'all. This is one of the exhibits that Russell and his team submitted for evidence, right? To show how much of the courtroom was restricted. Now, mind you, like I just read to y'all, other judges literally accommodated Judge Roach for Karmelo's trial, meaning moving their dockets around and basically rescheduling their court dates so that they could offer assistance, their bailiffs, their public workers to assist with Karmelo's trial. So that means in my mind that the damn near the whole courthouse was available to their use for their usage. If everybody moved their shat around, why was it so restricted even after? Look at the red, y'all. Now, mind you, this is just parking lot right here. In the front, that grass, where it's outlined in blue, that's just the parking lot. All of this that's red is the courthouse. And this little piece in the middle shows the only part that wasn't restricted. Make it make sense. Let's keep going. So, hey, Miss Eugenia. Hey, my love. They jumped him regardless of who is slimy ASS daddy is, them boys. Oh, shout out to Free, because I gotta show y'all something. I don't know if I'm gonna do it on this live, but somebody broke down the video again and showed, and that was in court. I don't want to say their name yet. Don't nobody put the name in the chat if you know who I'm talking about. But I'm gonna show y'all. I don't know if we're gonna be able to do it on this live or if I'm gonna have to do it on the next one. But somebody broke it down and showed how Karmelo was assaulted by more than one person. And the reason why they were able to break it down is because they were in courts. So they knew, according, now if we're going off of what they said in court, which we got to take with a grain of salt because they did so much corruptness thus far. But according to the video expert that did the video, that altered the video for the prosecution, they showed who was who in the video, which allowed the person to be able to see who attacked Karmelo. And it was definitely more than one person. More than one person, y'all. So we're going to get to that. Might have to do it on the next live. We'll see. So let me pull up this real quick. It's not opening on my damn chat GPT for some reason. So I'm going to have to do it off my phone and just read it to y'all. All right. Let me see. What did I have in my notes? On the record. Hold on, y'all. Let's see. Okay, so I wrote in my notes that only 9 members, and I put what Judge Cockroach needs to have on the record. Only 9 members of the media were allowed in per day. That's one thing. The public, including Karmelo's grandfather and aunts, were shut out from the trial. We know that. Only 8 family seats and the public had to register a day in advance just to try to get in, but it wasn't guaranteed even after that. Let me see. And let me say this. This was a huge mistake made by Judge Cockroach, y'all. Remember, when everybody had to fill out a form, kind of like a survey or whatever. They had to fill out this questionnaire form. And on the form, even media, on the form, and I think that was submitted into evidence also. Hold on. I could probably put it on the screen. Give me a second, y'all. I forgot about that. Let's see. 1 second. Let me find it. Where you at, baby? Defense rest. Hold on, y'all. I'm looking. Okay. Damn, where is it at? I just had it up too. Okay, here you go. Hold up, y'all. Hold up. Give me a second. All right. Where's the paper at? Okay, that's exhibit 3. All right. Hold up. I'm trying to find it. Exhibit 5. What is this? Legitimate media interview. Okay, that's from the interview. Okay. Damn, where is that exhibit? Hold on, y'all. I'm still looking for it. Okay, we got the thank you letter, but I need that media intake form. What is this? This is not it. Motion to dismiss. Thank you letter. Michael Proctor, termination. Okay, what is this? Credentialing and courtroom access email correspondence. Okay, I found it. My bad, y'all. I found it. Hold on. Let me send it to my email real quick. That's the one. All right. Okay. Come on, hurry up. All right, receipt. Okay. Now let me okay, now let me get it. Okay, let's take this one down. Because this is very, very important, y'all. This document right here, yeah, it's very important. Okay? Let me pull it up. All right. Let's share it. Okay. So this is the media request intake trial coverage sheet, y'all. Let me make it a little smaller so y'all can see it in full. This is one of the exhibits. Damn, I want it to be a little bigger. That's good. That's good enough. I think y'all can see it for the most part. So this is one of the exhibits that was submitted by the Dream Team for the motion for a new trial, right? And the reason why this was submitted, and this is crucial to Karmelo potentially getting a, whether it's going to be a conviction overturn or a new trial, because they didn't provide this. This all falls under his Sixth Amendment right. Okay. So if y'all notice, this was given to all people that was trying to attend the trial, that was trying to be in attendance. Media request intake trial coverage. Notice they had to put their name, contact name, email address, phone number, media type, request type. Mind you, y'all know anytime it's a red asterisk, it's required. Okay. So that's a key point to remember. Notice request type. They are able to check off or alternative or, some whatever they want plus alternative, whether it's credential, courtroom access, overflow room access. That is crucial. Let me tell y'all why. They didn't provide that. They didn't provide the overflow room. So them offering it and you got all of these people, and let me tell y'all another flex from the dream team is them getting in contact with people that traveled from all over to be in attendance. And this courthouse, aka Judge Cockroach, gave a media intake form basically letting them know, hey, if you can't get into the courtroom, are you okay with the overflow room? That's what that says in layman's terms, right? That's pretty much what that says. If you can't get into the main courtroom, are you okay with an alternative? So all people who filled this out had to check the boxes that apply. That's crazy. That's just, one little error, but it's major. Okay. That's a major, major error, y'all, because it show now, and let me tell y'all why also, because they utilize this media intake form and providing alternatives. Judge Roach was required to explain on the record why the overflow room was not made available. Did he do that? No. Okay. He didn't do it. Okay. I need that damn trial order, amended trial order motion filed from Judge Roach. If anybody can get me that ASAP, I would be greatly, greatly appreciative. I need that, y'all. I need that because that's where he's supposed to explain why he did what regarding restrictions for the trial, keeping the public out, etc., etc. Okay, so I need that form. I'm gonna try to find it, but if somebody finds it, send it to my email. Mods, please put my email in the chat, please. Thank you, Terry. Thank you for the fireworks supporting my goal, bro. I appreciate you. Thank you, thank you, thank you. I've seen people on the line for the overflow room one day. Yep. And they didn't utilize it. So let's keep going. But like I told y'all, this is very important. All right. So I also jotted down. Okay. All right. Well, I don't need this no more. Now let me go to my chat GPT real quick and let's get to the meat and potatoes, baby. Ooh, I'm excited, y'all. Because I know this finna make some shit shake. Okay. All right. Let's get to the Waller test. Now, the Waller test is something that it's a test basically. It's a 4-part constitutional test that a judge must satisfy before closing a criminal courtroom or excluding the public from part of the criminal proceeding. Okay? Did he do that is the question. That is what will determine if Karmelo qualifies for a conviction overturn just off of that basis or motion for a new trial. This has nothing to do with the self-defense. Emphasis on this has nothing to do with whether Karmelo is guilty or not. Okay? That's why this is so major, y'all. Because his conviction can literally be overturned off a structural error and lack of explanation due to restriction alone without even popping it about self-defense. So while they was trying to do their big one, thinking that the public was quiet about Karmelo and they can railroad him privately, oh yeah, they effed up big time. Because one thing about when you doing chat wrong, when you're wrongfully doing things, wrongfully convicting someone, wrongfully railroading someone, God don't sleep, baby. we the people might not see it all, but that person up there, oh, he's seeing it all. He's seeing every bit, even the corruption that we don't see, even the things they did that we don't see. Okay, so you said I saw in one of them exhibits they overturned somebody conviction. I'm finna get into that. That's what I'm finna get into. So I told y'all what the Waller test is. It comes from the U.S. Supreme Court case Waller versus Georgia. The Supreme Court held that the Sixth Amendment public trial guarantee applies to criminal proceedings, including suppression hearings. The 4 parts of the Waller test. Y'all pay attention because this is important. Number 1, these 4 parts. Judge Cockroach had to answer to every part of the 4 parts on the record. Not like that gentleman's deal that was done off the record in the judge's chambers. Yeah, no, this ain't that, baby. In order for Karmelo to not have a chance for a new trial or a conviction overturned, Judge Cockroach has to answer to all 4 parts of the Waller test, explaining, and not just in general, in specific grave detail, why he didn't allow public access, including live stream, which was never notated. Okay, never mentioned. This way it gets real sticky and it get real interesting, and that's why I say Russell them really they really pop they shat with this. They really pop, and I'm gonna tell y'all why in a second. Number 1, 4 parts of the Waller test. There must be an overriding interest likely to be prejudiced. The party asking to close the courtroom must identify a specific serious interest that would likely be harmed if the proceeding remained public, right? A vague concern generally is not enough. So basically what they're saying is Judge Roach has to give a reason. This is just number 1. Why public access would likely harm the proceeding, right? And he can't just say, oh, because it's too many people or because the trial is too controversial. He has to give specific grave detail why that, why he used that restriction. And he didn't do that. Okay? He did not go into detail. Thank you, Crystal. She say for always coming with the receipts. Thank you, my love. Thank you for that firework. I appreciate you. So number 2, and I need that, y'all. I need that trial order, amended trial order motion that Judge Roach submitted, because it basically tells, like, it's basically him giving his explanation as far as the Waller test is concerned, right? I need that. Even though I know what he said in it because I seen it on somebody else's channel, I want to read it here for y'all, just so y'all can see what he did and did not explain. And you would think if you finna railroad somebody, you gonna cross all your T's and dot all your I's. But they didn't do it. Fortunately for Karmelo. So let's keep going. Number 2, the closure can be no broader than necessary. The judge cannot simply lock everybody out if a smaller restriction would protect the identified interest. The closure has to be narrowly tailored. Okay? Number 3, and he had to explain that also. Seeing as how he only allowed 9 media per day, that's not a lot, y'all. That's very, very, very small. And why? Alone, and that's not even including the 25 seats for general public, and even some family members was fighting the public for those seats. Remember, Karmelo's grandfather and 2 of his aunts couldn't even get in. They was not supposed to be restricted at all. Let's keep going. Number 3, the court must consider reasonable alternatives to closure. Hint, hint, the overflow room access that they put on the paper as a request type, but didn't allow access. That's major. Let's keep going. The judge has an affirmative duty to consider other options. The U.S. Supreme Court later emphasized in Presley versus Georgia that courts must consider reasonable alternatives to closing procedures. So basically, um, not only did he limit public access to the overall court proceeding, but they said they was gonna have the overflow room, but didn't have it. That alone shows you that he didn't even explain why he wasn't gonna use the overflow room. Because if they, and shout out to Nika Knight, because I think she was the one who stated that they didn't find out until a couple hours before that they didn't have no overflow room access. I think that was her. Don't quote me. But why would you offer it and then close it down and not use it for courts? And not only did he do that, he didn't explain why they didn't have that access. See, he would have had a better shot with that part if he wouldn't have had that request type on the media intake form. But because he added, and it was a required question for people to check off, and you didn't have it, it's even more detrimental. Okay? So let's keep going. And he didn't give no reason as to why he even shut down the overflow room access. And for the ones that's wondering what that is, overflow room is basically another room in the courthouse where if the courtroom, the actual courtroom is full, they'll utilize and offer another room, an alternative with a monitor where people can sit in there and monitor the court proceeding via TV screen. Okay? They didn't use that. So, number 4, the judge must make adequate findings supporting the closure. This is a big one. The judge must put findings on the record, y'all. Hint, hint, the trial order, the amended trial order motion. Yeah. The judge must put findings on the record that are sufficient to support and explain the closure, and not just little in general vague findings, right? It has to be specific in grave detail as to why, how allowing the public would have been harmful to the proceeding. He had to really go into detail, and he didn't do that. From my opinion. So, Texas judiciary guidance likewise describes the need to consider reasonable alternatives and make adequate findings on the record. Y'all gonna see when I get my hands on that trial order, that amended trial order Judge wrote submitted. Y'all gonna see exactly what he explained and didn't explain. So, in plain English, a judge generally cannot say courtroom closed or family only. There's not enough room, and leave it at that. He got to really, really go into detail as to why they're not allowing access. The record needs to show why the public was excluded, what specific interest was threatened, why a narrower solution wouldn't work. Hint, hint, the overflow room. What alternatives were considered. This is how you know they didn't even consider alternatives, because they put the overflow room in the media intake form and then basically say, we not letting y'all sit here, or we not using the overflow room a couple hours before. So that's how you know they didn't even offer alternatives or explain why they didn't offer none. So, and Derek Jackson, the initial PO public officer, his firing, and shout out to rest of them because they put that as an exhibit also. His firing is a big indicator of, in my opinion, some railroading too. Some corruption going on, child, because they fired it. His firing also shows how they were really trying to be real secretive with this trial. They didn't even want people to know the days of the trial. That's why Derek Jackson was fired. He was fired for giving out public information. Public officer Derek Jackson was fired for giving out public information, allegedly, because I wasn't there. But yeah, they replaced him, y'all, because he gave Christopher King the uh the docket date, or the date of the trial proceeding. And that's supposed to be public record. He didn't give him no secret restricted information that he wasn't supposed to give him. That is public record information. That's how y'all know it's some backhanded, corruptive, railroad shat going on, or then went on, child. Let's keep going. So, hold on, let me see where I'm at. This matters because the Texas judiciary itself states that the open courts provision of the Texas Constitution requires courts to maintain public access, and that in most cases the public is allowed in the courtroom during proceedings. Okay, hold on. Okay, hold on. Let me see y'all read. Based on the filing. Let me see. One important legal distinction first. Let me see. Emotional. Okay, so the biggest problem, the judge allegedly restricted access without doing a Waller analysis on the record. The Texas Court of Criminal Appeals has been very clear. Before a courtroom closure can be justified, the court needs a concrete overriding interest. A closure no broader than necessary consideration of reasonable alternatives and findings adequate for an appellate court to review the decision. Broad or generic concerns are insufficient. Okay? So, let me see. Reporting on the motion says. Okay, let me read this. The new motion argues, and that's the one that we kind of, went through a little bit in the last live, that Judge Roach's restrictions amounted to a closure of the courtroom imposed without the findings the law requires. Reporting on the motion says the courtroom had only about 24 public seats during the trial. People lined up as early as 5 a.m. and reportedly as early as 2 a.m. on the verdict date. And there was no overflow room available during testimony. This is crazy. Thank you, Terry Bro, for the fireworks. I appreciate you, my love. So that is the core alleged mistake. It is not simply the courtroom was small. The constitutional question is, before imposing restrictions that allegedly function as a closure, where is the Waller analysis and where are the specific findings supporting it? Texas highest criminal court has reversed. This way, we get into the meat and potatoes now, y'all. Listen to this. Texas highest criminal court has reversed where a judge failed to make findings sufficient to justify closure. In Lilly versus State, the Court of Criminal Appeals, hold on, something on my phone, my bad, said in Lilly versus State, the Court of Criminal Appeals said ordinary, correct under any theory, reasoning does not substitute for the specific findings required in a Sixth Amendment public trial analysis. Here's how Judge Roach's actions allegedly fail each of the 4 Waller factors. Y'all ready for this? Y'all ready for this? It's getting juicy, child. Let me say that again, y'all. We got 278 in the building. Y'all, please hit the like button. Let me take this off the screen. Hold up. And just put myself. This is where it gets juicy, y'all. Okay. Here's how Judge Roach's actions allegedly fail each of the 4 Waller factors. Number 1, overriding interest likely to be prejudiced. The judge needed to identify a specific interest threatened by an open courtroom and connect that interest to concrete facts in this case. Security, jury contamination, witness protection, or courtroom order can potentially qualify, but Texas precedent says generic concerns are not enough. So basically, him just stating that he closed the courtroom down or had such strict restriction from the public for the purposes of security, jury contamination, witness protection, or courtroom order, that's not enough. It got to be more specific and grade in detail. Those are too generic, basically, is what it's saying. Thank you, Terry, bro. Thank you for the fireworks, my love. Oh, you know I'm coming, Michelle. I'm coming, sister. What, Tootie? Hold on, y'all. Close my door. My bad, y'all. That was Ham, child. So let me keep going. But Texas precedent says generic concerns are not enough. In Stedman, even security, Stedman versus State for the ones in the back. Even security and an emotionally charged trial were insufficient because the judge failed to identify a specific threat or incident demonstrating the danger in that particular case. Stedman versus State. Hold on. So if Roach's reasoning was essentially high profile case, limited space, security, intense public interest, the problem is that those concerns may be too broad unless the record contains specific facts explaining the actual threat and why public access would prejudice the identified interest. And let me tell y'all something. Where he messed up at. Remember that little letter I read y'all of gratitude? Noting how all of these other counties assisted. They offered their officers, bailiffs. They had the fire marshals, what it was, McKinley, Texas, McKinley Police Department, Plano Police Department, I forgot the other ones, okay? Frisco, it was a few. It was like 4, plus the fire marshal, plus the other judges moved around their dockets. So they had all of this rearranging just to restrict the public. All of this extra security just to restrict the public. Make it make sense, y'all. Where was the threat? Where was the threat to restrict the public to this magnitude, including some of Karmelo's family members? Close family members, might I add. Where was the public threat? And you can't say in intense, emotionally charged supporters or anything like that. It has to be way more vague. I mean, way more broad. Okay. Thank you, Terry, bro. Terry cutting up, child. Terry, like, we gonna reach this goal. I appreciate you. So hold on. Let's keep cooking. Where did I stop? Hold up, y'all. Prejudice. The problem is that okay, let me read that part again. So if Roach's reasoning was essentially high profile case, limited space, security, intense public interest, the problem is that those concerns may be too broad unless the record contains specific facts explaining the actual threat and why public access would prejudice the identified interest. It's getting good, baby. It's getting good. Thank you, Miss Patrice, for the meat and potatoes queen. Thank you, my love. Thank you for supporting my goal. And thank you again, Terry, bro. Terry, listen. Terry said, I'm gonna clear out this goal, period. I appreciate you. So let's get to that is the Waller problem number 1. What I just read to y'all. That's part 1. Number 2 of how Judge Roach went against the Waller. Okay. Number 2, the restriction allegedly may have been broader than necessary. The defense points to severe limits on public seating. Contemporary reporting said there were roughly 24 public seats with about 150 people outside the courtroom on the second floor unable to enter on the verdict day. Other reporting described only 27 members of the public getting seats on the first day of testimony while around 100 people waited outside. Why they didn't open the overflow room? It sounds to me, and this is just my opinion, allegedly, because I wasn't there, but it sounded to me like because they allegedly knew they was finna railroad Karmelo, they didn't want those people in there because they didn't know what the F was going to happen when that verdict came out. What y'all think? I'm thinking because they knew they was finna railroad him, they knew people was going to be upset. Hint, hint, all the extra security. Because if you don't know what the outcome is going to be, why would you plan so far in advance to bring in all the like officers from all the counties, the fire marshal, all the extra bailiffs? They had all of that to even for a closed courtroom. Damn near. They didn't know, and this was a jury verdict. This wasn't the judge. This wasn't a bench verdict. This was a jury verdict. So that means they didn't know what the outcome would have been. Whether Karmelo was going to get self-defense, well, it's seeming like they knew ahead of time because a lot of people didn't state it. He was convicted long before he even went to that trial. All white jury. And when let's say a non-black jury, because some of them was, a different background, a different ethnicity, but they wasn't black. Okay? So that's what is given to me. They were scared of what could have happened because they knew what time it was with that verdict, and they knew that he was going to be convicted no matter what. That's what is given. Because who the hell prepares this immensely that early on, y'all? They had all, if you paid attention to that gratitude letter Judge Roach put out, oh yeah, that much preparation. And remember, I think he said in the interview, he had been prepping for this trial 6 to 8 months prior. Why though? Why? Because the public had went quiet. Remember, it was a time period where the public was completely like, it's almost as if Karmelo's case was swept under the rug. And that reasoning because so many people didn't even see this making it to trial because of the lack of evidence and the stories that was being, stated or spread amongst the streets. Nobody seen this even making it to trial. They didn't even think the grand jury was going to even pick this up because it was just some booty, basically. So it's like they knew what they was doing. And then when you think about that gentleman's deal, that adds even more sauce to it for a planned conviction, in my opinion. That's some crazy work. So hold on, let's keep cooking, y'all. Number 2, that the restriction allegedly may have been broader than necessary. The defense points to severe limits on, I read that. Never mind. I read that. That was number 2, y'all, about the seating. Now, limited seating alone does not automatically equal an unconstitutional closure. That distinction matters. But the defense's argument is essentially that the cumulative restrictions effectively close the proceeding to much of the public. Okay? That cumulative effect concept is important because Lilly says Lilly versus State, as a defendant does not necessarily have to prove that a particular person physically reached the door and was expressly told you cannot enter. A reviewing court looks at the totality of the evidence and whether the court took every reasonable measure to accommodate public attendance. Did they do that? No. Did Judge Cockroach damn, I done lost my thought. Did Judge Cockroach's efforts utilize everything possible, every avenue possible to accommodate the public for Karmelo's trial? We all know the answer to that. Look at the people that was complaining that couldn't even get in, that traveled near and far. They couldn't even get in, most of these people. So the question becomes, did the access system itself function as a practical barrier to public attendance? If yes, the court then has to justify the scope of that restriction. He didn't do that, y'all. And I'm telling y'all that because I've listened to someone break down the trial order, the amended trial order motion that he submitted, basically explaining why he made certain restrictions. Okay? I gotta get my hands on that document for y'all. I'm gonna see if I can find it when I get off live. That is Waller problem number 2. Number 3, the strongest argument may be the alleged failure to consider reasonable alternatives. This is the part that jumped out at me. Guess what one of those reasonable alternatives is, y'all? The overflow room that was denied. The overflow room that was denied. And not just the overflow room. What about all the courtrooms that these other judges accommodated Judge Cockroach with by moving their dockets around? Why didn't we utilize those? What was the purpose of them moving around their dockets if we weren't going to allow public access anyways? Got to make it make sense. And that's basically what this is stating. It has to make it, his explanation of these restrictions have to make sense. And it's no way for him to make them make sense, in my opinion. It's no way. Because they wasn't banking on this. They wasn't banking on this Dream Team 2.0 to put belt to ass for Karmelo. They wasn't even banking on Karmelo having a team like this. Remember, they were shutting down every goddamn GoFundMe, GoSendGo, any type of donational money avenue for Karmelo. These weird ass people got it shut down. So they wasn't banking on a free defense team, let alone one of this level of excellence. Okay? They was not banking on this, baby. Hint, hint, why they are holding those transcripts like the most valuable diamond, like the emerald's jewel. Okay, listen, they are holding so tight on, child. Listen, they holding them transcripts like that damn bang was on Gorilla Glue Girl head. Okay, that's how tight they holding on to it. So, according to the defense motion and reporting on it, an overflow option was available during jury selection, but was not continued once testimony began. So they made the overflow room available for jury selection, y'all, because they needed it. Because there was so many in the jury pool, they needed the extra room. But once testimony started, they shut it down again. That's interesting. And they got to explain that. Oh, yeah. Oh, yeah, baby. He got to come with his big one explaining why that overflow room was shut down. So, that the motion expressly frames its public access section around an overflow room provided and then withdrawn. I just showed y'all that in the media intake form. And that is legally significant under Waller and Presley versus State. Okay. Let me see. The Supreme Court has said the judge has an affirmative obligation to consider reasonable alternatives. The defense does not have to hand the judge a perfect list of alternatives first. Texas courts quote Presley for the proposition that trial courts may take every reasonable measure to accommodate public attendance and consider alternatives without the defendant proposing them. This is how we know they didn't consider alternatives, because they did everything in their power to keep the public out. They did everything in their power to restrict the public. So you know they didn't consider alternatives. They barely wanted people in the trial, in the main courtroom, let alone the overflow room. 25 seats here, 9 media a day. Then they had to fight over the access. The people was out there scrubbing elbows. They was out there scrubbing elbows to try to get a seat, child. That is ridiculous. For a courtroom that size, where they could have utilized the overflow room. Thank you, Kenneth. Kenneth say for a great broadcast. Thank you for that Cash App blessing. I appreciate you. Okay, so let's keep going. Let me see, what did I okay, possible alternatives could have included an overflow courtroom with an audio or video feed. That's one, y'all, and let me tell y'all that. That's a little piece of tea. That's one thing he didn't even explain. Remember, Judge Cockroach was required. Y'all know what required means. To explain why he had these restrictions. That wasn't even mentioned in his motion. The live audio or video, that wasn't even mentioned. So you know they got it right there. Let's keep going. A larger courtroom, if reasonably available, a modified seat allocation, or another access arrangement tailored to the specific security concern. So this is my question before I continue reading. If they had so much accommodations made available from 4 to 5 other counties, police departments, the fire marshals, all of these bailiffs from other judges, all damn near the whole courthouse of workers assisted for this trial, why weren't they able to utilize this extra security to have an overflow room? Possibly another courtroom with a monitor? Why? Why was his 6th Amendment violated? If they had all of this extra security via cops, fire marshal, bailiffs, why? What was the purpose of not utilizing having the public, allowing the public, and audio, video, live streaming, extra media? What was the purpose of hiring all these people? Are these people volunteering? One of the two. If you wasn't going to utilize them. It seems to me like they had more than enough security to at least allow 100 people. At least. But like I said, in my personal opinion, I feel like they were scared because they already knew they was finna railroad Karmelo. Hence why they had so much security. They knew what time it was. They knew Karmelo wasn't getting out of that situation a free man, let alone a man with 5 years or no years. They knew they was finna stick him. Okay? Hint, hint, why they had so much security even with restricted public access. They knew that verdict was finna be unfavorable. So, and this is where a very recent 2026, let's get the Hernandez, baby. Wait, do I want to do that part or go straight to, let me see how much time we got. Okay, I'm gonna do that part. And this is where a very recent 2026 Texas appellate decision, Hernandez versus State, becomes important. Remember, cited case law in Carmelo's motion is Strickler versus State, Hernandez versus State, and Stedman versus State. And two of those were as recent as this year. Oh yeah. Oh yeah. That's one that's where Wilson them got in where they fit in, baby. That's where they got it. See, they know the appeals, the likeliness of of appeals to be, cases to be overturned is very unlikely, especially in Texas. So they worked around that. That's what this is giving me. They worked around. They coming at it from all different angles to get one good result. So, um, let me go up before I read that part. Hold on, y'all. Space now. No, I want to read that. And this is where a very recent 2026 Texas appellant decision, Hernandez versus State, becomes important. In May, Hernandez was overturned in May, y'all, 2026. That's like 2 months ago. The 14th Court of Appeals addressed a closure based on a judge's concern that there was no available courtroom space. The appellate court said the judge had not engaged in a Waller analysis, made the required findings, or considered reasonable alternatives. It specifically stated that space and overcrowding can be legitimate concerns, but they cannot simply outweigh the defendant's Sixth Amendment rights. Are y'all listening? Y'all picking up what I'm putting down? You welcome, Miss Deborah. She said, thank you, Lupac. Enjoy your channel so much. Thank you, my love. I appreciate you. Hey, Miss Duncan. Are y'all picking up what I'm putting down? See, people out here talking about, oh, it's so hard to get an appeal. It's only like 4 or 5% of appeals overturned in Texas. What about Sixth Amendment? What about Sixth Amendment violations? Oh, yeah. And this has nothing to do with self. This has nothing to do with whether Karmelo was innocent or guilty. This is just on a violation of his rights. Let's talk about it. Let's talk about it. Hit that like button, y'all. Support the goal. I don't know if the goal is clear or not, but whatever. Okay. So, space is, did they say read that again? Space is not automatically enough. The judge still has to consider alternatives. So the judge in Hernandez versus State thought that he could just limit. See, even the judges have to answer the people. Ain't no judge that egotistical or, well, some of them act like they are that high and mighty until you got to do your little 1-2 on their ass. Okay. But even the judge thought that he could just hit them with, oh, we don't have enough space to accommodate. And guess what? Oh, my thing didn't clear out. Guess what the 14th Court of Appeal said? Conviction overturned. All your work on that case just went overturned because you didn't accommodate the public. Ooh, spicy. So let's keep going. So if an overflow room actually existed and was used during one portion of the proceedings, but then public access was drastically restricted after it was withdrawn, the obvious appellate question is, why couldn't the overflow accommodation continue? Now, what I'm explaining to y'all is how this is important with Karmelo's case. Remember, that media intake form I just showed y'all, it showed where the overflow room was offered as an alternative. It even in the motion, they Wilson them also show how the overflow room was utilized during jury selection, but then rescinded, taken back once testimony started. Why? See, that's where they messed up, because they showed that they had alternatives, but didn't utilize them. They only utilized it for jury selection. Let's keep going. Hold on. Let me see where I stopped. Okay. And where did the judge explain that on the record? That may be one of the defense's stronger Waller arguments. Number 4, the judge allegedly failed to make adequate findings supporting the restrictions. This may be the cleanest legal issue of all. Waller does not permit an appellate court simply to invent reasons for the judge after the fact. The findings must be specific enough for a reviewing court to determine whether the closure was constitutionally proper. In Lilly, the Texas Court of Criminal Appeals said it could not determine why the judge had rejected public access and held that the absence of the required factual findings made the closure improper. Emphasis on improper. Okay. In Stedman, the Court of Criminal Appeals likewise rejected findings that were too generic and emphasized the need for specific concrete facts showing a tangible threat in the particular case. So the defense is essentially asking, where are Judge Roach's specific Waller findings? Not general courtroom rules, not a media access order, not this case is high profile, not security is too tight. They are looking for something like the court finds X specific threats exist because of A, B, and C. The court considered alternatives 1, 2, and 3. Those alternatives are inadequate for these specific reasons. Therefore, the court is imposing this narrowly tailored restriction. If that analysis is absent from the record, the defense has a serious Waller argument. Shout out to Russell and the Dream Team. Baby. The part involving Karmelo's grandfather and aunts is especially important. Let me tell y'all why. The motion, now who calling me? I'm going to call you back. Y'all ain't heard me. The part involving Karmelo's grandfather and aunts is especially important. Remember I told y'all the grandfather and the aunts couldn't get in. Now let's get into it. Let's cook a little bit on that. The motion reportedly includes allegations and exhibits concerning members of Karmelo's family being unable to access the courtroom. I would pay very close attention to the exact affidavits and recordings attached to the motion. Why? Because Stedman itself, Stedman versus State, involved the exclusion of the defendant's family members during voir dire. The Texas Court of Criminal Appeals ultimately held that the judge's generic concerns about security and jury contamination were insufficient and reversed for a new trial. So, in Stedman versus State, even though the judge gave reasonings, they were too generic. Too generic, meaning he didn't give grave in detail reasonings for not offering alternatives. Okay? Hold on, y'all. 1 second, y'all. Hold on. Okay. That was one of my cousins, child. I even got their name saved in my phone. All right. So, yeah, that conviction was overturned and reversed for a new trial, not because the judge didn't give a reasoning, but because they were too generic. Too generic and not specific enough. Not good enough. Okay, let's keep going. The court specifically noted the absence of evidence of family outburst, prior disruptive conduct. So basically, the judge was telling the appeals court that the family was having outbursts and they had prior disruptive conduct, or attempts to communicate with the jurors, right? It rejected speculative fears as insufficient to defeat the Sixth Amendment public trial right. What? Hold on, y'all. Okay, so let me see. Where did I stop? So, if Karmelo's grandfather and aunts were denied, and they were, access without any individualized security concern tied to them, the defense has Texas precedent that is remarkably relevant. What Karmelo Papa did, y'all? What did his aunts do to be? I'm laughing, but it ain't funny. I'm just laughing because these people were restricted without reason. With the security detail was a little too tight. A little too tight that they wasn't even paying attention to who was getting in and who wasn't. That's crazy. So, or were they? And it was purposeful. One thing, let me see. Hold on, y'all. Hold on. Okay, the Sixth Amendment guarantees a public trial. It does not automatically recreate a constitutional right to live stream or televise a criminal trial. The stronger argument is the combination alleged by the defense, severely limiting public seating, plus people lining up before dawn and still being unable to enter, plus an overflow accommodation allegedly provided and then withdrawn, plus family members allegedly unable to access proceedings, plus no adequate Waller findings or on record consideration of alternatives. Okay? Exactly, Frank. They forgot about that though. He was up in there signaling witnesses and shit. But I did hear in the judge's defense, even though y'all know how we feel about him, I did hear that Jeff Metcalf was kind of like sitting behind. It's like sitting behind. Hold on, y'all. 1 second. Okay. All right, hold on. Let me see. My bad, because I'm getting messages while I'm trying to read my stuff, child. All right. Let me see. Okay, I read that part. Texas law specifically recognizes that courts should look at the totality or cumulative effect of access restrictions when determining whether a proceeding was effectively closed. All right. The alleged mistake was not simply that Judge Roach limited seats. Come on, I don't know why my computer be timing out like this. Okay, the alleged constitutional mistake was that he imposed an access system that the defense says functioned as a courtroom closure without first doing and documenting the constitutional analysis Waller requires. And the overflow courtroom issue is potentially huge because it gives the defense a very obvious response to the third Waller factor. There was a reasonable alternative. The court had already demonstrated that the alternative exists with the media intake form, y'all. So they showed that the alternative existed, but where's the explanation of why it wasn't utilized to assist the public? Okay. All right. Let me see. Hold on. The state may respond that the courtroom was never legally closed. That available public, this what the state may say. That the available public seats were filled on a space available basis and that the restrictions were ordinary security and capacity controls. NBC reported that during jury selection, the public was allowed to fill available seats, and the county's order said seating was space available. That means the first major fight is probably whether these restrictions legally constituted a closure at all. If a court finds there was a closure, then Judge Roach's alleged lack of specific Waller findings and consideration of alternatives becomes much more dangerous for the conviction, y'all. Ooh, getting good. Okay. All right, let me see. Hold on here right now. Damn. And what's crazy is Hernandez versus State. That appellate decision came out May 19th, 2026. Literally weeks before Karmelo's trial, y'all. And it deals with a judge restricting a courtroom over space, baby, and failing to consider alternatives, which is similar to Karmelo. Let me see. Okay, so let's get into the meat. We just did the potatoes. Now I'm about to tell y'all those 3 case laws that was cited by the defense, by the Dream Team, for Karmelo's situation in the motion. Those 3 that are, if you ask me, very beneficial to Karmelo potentially getting a conviction overturned or a new trial. Okay? Strickler versus State, Texas 2026. Hernandez versus State, Texas 2026. And Stedman versus State, Texas 2012. I wonder why they didn't do Lilly versus State. I don't know. But anyways, these good. So they could have added Lilly also, because that one was kind of in reference to spacing and stuff like that. Lilly versus State in Georgia. But it's all good in the hood. So Strickler versus State, Texas 2026. The conviction, y'all pay attention because it's going to state why these convictions were overturned. Okay. And y'all be able to hear or pinpoint the relevance to Karmelo's situation. Strickler versus State, Texas 2026. The conviction was reversed because the courtroom was closed to the public during jury selection. I don't think y'all heard me. Strickler versus State in Texas 2026. I think this one was both. I think both was in May, but don't quote me. I know Hernandez happened in May. I don't know about Strickler, but I think it did. But this year, the conviction was reversed because the courtroom was closed to the public during jury selection, and the judge did not consider all reasonable alternatives before excluding the public. That violated Strickler's Sixth Amendment right to a public trial. Conviction overturned. Hernandez versus State, Texas 2026. Shout out to the Dream Team for citing this pressure. Okay? Citing this pressure, baby. Hernandez versus State, Texas 2026. The conviction was reversed because the public was excluded during jury selection due to courtroom space concerns, but the judge did not conduct the required Waller analysis, make adequate findings, or consider reasonable alternatives to closure. So this judge was spicy. Whoever the judge was in Hernandez versus State, oh, he had an ego, baby. He said, I ain't doing it. Okay? He said, I ain't doing it. Period. And overturn. Conviction, overturn. Hernandez versus State. Stedman versus State. Case law number 3. Texas 2012. All of these 3 case laws are in reference to Sixth Amendment violations, which is highlighted in Karmelo's motion for new trial. Pick up what I'm putting down. Stedman versus State, Texas 2012. The conviction was reversed because the defendant's family was excluded, grandpa and aunties. One time for the grandpa, two time for the aunties. Period. Conviction was reversed because the defendant's family was excluded from jury selection based on general security and jury contamination concerns. The judge lacked specific concrete facts justifying the closure and failed to consider reasonable alternatives. Conviction overturned. Notice, none of those three case law sightings have anything to do with guilt or innocence, self-defense or murder. All are violations of Sixth Amendment rights. Those amendments are in place for a reason. Okay? So, and y'all, this look how cold and pressure this put together is. Shout out to the dream team, because this ain't even like, this is just only one aspect of error. This ain't counting the corruption and the railroading, the spectacle of a trial that they had. This ain't even counting none of that. This ain't even counting the reasons for appeal. That's some crazy work. The common denominator in all three Texas courts found a Sixth Amendment public trial violation involving courtroom closure and failure to satisfy Waller requirements. Because a public trial violation of this kind is structural error, reversal does not require the defendant to prove ordinary harm. Meaning, this is not about guilt or innocence. He does not have to prove ordinary harm. All they got to prove is the judge didn't follow the Waller analysis or didn't respond to the four aspects of the Waller analysis. And if he did respond, it couldn't just be general reasons. It had to be specific and grave detail. So he couldn't just say, "Oh, I closed the courtroom because of seating issues." No, he had to give specific reasoning, or he couldn't say, "Oh, the family is known to be wilding out," or the family has a history of wild courtroom behavior. No, he had to go into detail. Let me see. That's crazy. Even more so, shout out to them, because Strickler and Hernandez are both from 2026. That's what makes it even crazier, because it's like, damn, these convictions was just overturned 2 months ago. 2 months ago in Texas for the same shit almost. That's how crucial those are. So, y'all, I hope y'all enjoyed this live stream. We right at the 2-hour mark, baby. Hour and 58. Look at me. Look at me with my little time and child. Period. Thank you to the dream team. They did a big one. And they did a big one without the transcript. Imagine what they can do with the transcript. Hint, hint, why they holding on to the transcript so tightly. Because they know what Russell them working with, y'all. They got to know. They know what that dream team working with. These are the best of the best. Oh yeah, baby. They trying to stumble them up. They trying to decrease the chances of an appeal even further. But they wasn't expecting this Sixth Amendment right here. They wasn't expecting this Sixth Amendment pressure. They was just banking on, oh, they just gonna file a little raggedy appeal. Most of them get over, most of them don't get overturned. And no, they wasn't expecting them to hit them from every angle. Big shout out to the dream team. All right, y'all. So I'm gonna get up off of here. God spare. I may be back later. It just depends on what time I get back from the event. If it's too late, then y'all see me tomorrow. But yeah, I hope y'all enjoyed. I hope y'all got some good tea information from this live. I feel like the more things come out, the more hope we get as far as Karmelo coming home, because a lot of errors and mistakes were made with his process. And it's so sad. It's so unfortunate because it's like, damn, is this what we got to deal with? Like, are we not human like the rest of these people? Do we not bleed the same type of blood? What's really good? Why are we treated so unfairly? Is the question. Why are we not treated with the same respect and judicial law / system as everyone else? Just sad. But all right, y'all. I love y'all. Thank you, Faye. Thank you, Michelle. Thank you, Wildlife, Miss Patrice. I will see you guys. Like I said, if I don't see y'all tonight for a nightcap, because it is Saturday. Sometimes I do nightcap lives, and I do need to explain some stuff about the saga with the legal stuff with that. So we'll see. If not, it'll be tomorrow. I love y'all. Stay safe in these streets, because y'all know these YouTube streets ain't safe, baby. Thank y'all for all the support, the engagement, the supers, the cash out blessings. I will see you guys tomorrow. Bye, y'all. Or later.
Y'all know what time it is. The truth teller in the spot. Always bring the facts. Yeah, she make the fake stop. Clearing out the noise. Never let the lie rock. Nope. Say it with me loud. Wipe them down, pop. Wipe them down, pop. Wipe them down, pop. Wipe them down, pop. It's Lil Park, baby. Wipe them down, pop. Wipe them down, pop. Wipe them down, pop. It's Lil Park, baby. Receipts on deck, she gon' air that out. Lil Park, wipe them down. If it's cap in the chat, she gon' call that out. Lil Park, wipe them down. Came with the proof, better watch it now. Lil Park, wipe them down. If it ain't fast, don't come around. Lil Park, baby. Wipe them down, pop. Wipe them down, pop. Wipe them down, pop. Lil Park, baby. Wipe them down, pop. Wipe them down, pop. Wipe them down, pop. It's Lil Park, baby. She a Louisiana with truth on blast. Lil Park, wipe them down. Receipt so strong that the lies won't last. Lil Park, wipe them down. When she step in the spot, all eyes on her. Lil Park, wipe them down. Expose real quick, make the face to turn. Lil Park, baby. Who got the truth? Lil Park. Who bring the proof? Lil Park. Hands to the left, hands to the right, wipe them down. Club lit up all night, wipe them down. Who got need? She OB. Lil Park, baby. Wipe them down, pop. Wipe them down, pop. Wipe them down, pop. Lil Park, baby. Wipe them down, pop. Wipe them down, pop. Wipe them down, pop. It's Lil Park, baby. Truth don't beat, you gon' stand on that. Lil Park, wipe them down. Blocking the trolls, never looking back. Lil Park, wipe them down. Whole crowd move when the name get loud. Lil Park, wipe them down. She the voice of the people and she shut them down. Lil Park, baby. Truth too strong, wipe them down. Pop, pop. Crowds sing along, wipe them down. Pop, pop. From the booth, she a beast, wipe them down. Pop, pop. It's Lil Park, baby. Shut it down.